Bill to the House.
I understand that this is not a split call, so we'll. Lewisa Wall, you have the call.
Kia ora. Thank you, Mr. Speaker, and thank you for the opportunity to speak. This is the second reading of the Lawyers and Conveyancers Amendment Bill, which was referred to the Justice and Electoral Select Committee after its first reading and was reported back on the 13th of April 2011. I'll begin by saying Labor does oppose this bill, and I will talk about why we oppose this bill. So really the objection, as outlined by my colleague, the Honourable Phil Goff, is really about Part 1 of the bill and the reinstatement of Queen's Counsel. Moana and I were just talking, actually, whether that's Queen's Counsel or Queen's Counsel. Within the hierarchy of the legal profession. There is no other profession that seeks to reward certain of its members by giving them an elevated position conferred by a government process. On 17 June 2009, the Attorney-General, the Honourable Chris Finlayson, announced his intention to reinstate the title of Queen's Counsel. At the time he said, and I quote, "The government is taking these steps to protect the essential independence of the inner bar. The looser rules for eligibility as senior counsel introduced by the previous government threaten to dilute the independence of our most senior advocates." So that intention was echoed in the report, the majority report of the Select Committee. But what this bill does is restrict the senior title to barrister's sole. Such a move is archaic and not reflective of the modern society most of us now live in. Queen's Counsel, as its name indicates, is about royal patronage. The first Queen's Counsel was appointed by Elizabeth I as her legal advisor. That is the foundation of the process that this government is seeking to reinstate. In 2006, we made significant changes to reflect our own developing legal system. That was no longer tied to the systems that had developed in England. A number of cases had recognised that development, and the Privy Council in Invercargill City Council in Hamlin in 1996 declared that New Zealand law should not be deflected from developing its own course in isolation to England. Why then would we take this backward step of trying to retie ourselves to England? It kind of doesn't make sense, even from someone who has had nothing to do with this bill up until this point in time. There is no logical or reasonable basis to argue reinstatement and restriction will result in independence. The title, Queen's Counsel, clearly conjures up a connection with the Crown and government. The term senior counsel does not do that. It's what we currently have. It donates the recognition of people who have attained seniority within the legal profession. It speaks of independence, not alignment with one of the treaty partners. It is a practice followed in a number of Canadian states and the federal government. Senior counsel is a term used in Australian states since 1993, albeit we seem to have encouraged, however, Queensland's Attorney-General to look at reinstatement too. South Africa, Trinidad and Tobago and Guyana all use senior counsel, and Nigeria, India and Bangladesh use senior advocate. As to restricting applicants for the senior position to barrister's sole, that too is not reflective of the wider processes available in law. We have lawyers who specialise in mediation and negotiation, in alternate dispute resolution, as well as those in other areas. There are many aspects to giving advice, but the suggestion that barristers' sole are more independent than those in a firm or company or organisation is ludicrous. Most barristers' sole have spent a significant portion of their career in firms or companies or organisations before becoming barristers' sole. They have the same obligations in terms of giving advice whether they are in a firm or barristers' sole. The public is entitled to that. The public is entitled to ensure that our senior counsel has a range of skills to meet the demands of the position. The public, and surely any suggestion that a nominee is not able to fulfil his or her obligations would discount any nominee from appointment. So there, in conclusion, seems to me to be no reasonable or logical basis for this backward step, and for undoing the positive steps taken in 2006 to allow Aotearoa New Zealand to develop its own legal structure, and to acknowledge that by casting off a title that reflects another country's history actually is to deny our country our own history that we have developed here in our country. Kia ora.
Ian McKelvey.
Thank you, Mr. Speaker. It's